Hello, friends. Welcome you all once again to Beginners IAS YouTube study channel. So far, we have discussed about national emergency under Article 352. Now, we are going to discuss about President's rule under Article 356, that is, emergency provision. Before discussing Article 356, let us see what is Article 355. This Article 355 imposes a duty of the center to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. And then Article 356. It is the duty in the performance of which the center takes over the government of a state. Under Article 356, in case of failure of constitutional missionaries in state, that is, under Article 355, it monitors whether the government, that is, state governments, follows the constitution or not. If it feels that violates the constitution, and then this Article 356 can be used. This is popularly known as presidential rule. It is also known as state emergency or constitutional emergency. Let us see the grounds for imposing presidential rule. That is Article 356 and another is Article 365. First we will say about Article 356. This Article 356 empowers the President to issue a proclamation of state emergency if he is satisfied that the government of a state cannot be carried on in accordance with the provisions of the Constitution. Note, one should note here that the President can either act on a report of the governor of the concerned state or otherwise even without the report of the governor of that concerned state. So let us see about Article 365. So this Article 365, it is also one of the most important article under which a president rule can be imposed. Let us see how. When a state fails to comply with or to give effect to any direction from the center, that is, it will be lawful for the president to hold that the situation has arisen in which the government of the state cannot be carried out or in accordance with the provisions of the Constitution. So let us see the recent example, that is farm laws. So there are 3 farm laws passed by the parliament, which means the state government also has to implement such farm laws. It has to follow such rules. Suppose if it violates to implement, then this article under 365 we can able to impose a president rule. Let us move on to the approval and duration. This presidential rule can be approved by the parliament. It has to be approved within the 2 months if both Lok Sabha and Rajya Sabha are in session. So here one has to note that if the proclamation of president's rule is issued at the time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha take place during the period of 2 months without approving the proclamation, then also this presidential rule can be imposed. The one condition is that the proclamation survives until 30 days from the first sitting of Lok Sabha. After it reconstitution, it has to be approved. So, and also before that, the Rajya Sabha approves it in the meantime. That is one of the most important conditions present here. And how long this proclamation of state emergency will survive? if gets approved by both houses of the parliament, that is Lok Sabha and Rajya Sabha, this presidential rule continues for 6 months. It can be extended for a maximum of 3 months. 1 year has to note that it is extended only up to 3 years. So this extension also need approval of the parliament every 6 months. This proclamation of emergency, that is presidential rule, can be imposed by using a simple majority. And then what happens after 44th Amendment Act of 1978? So this amendment introduced a new provision to put restraint on the power of parliament to extend a proclamation of presidential rule beyond 1 year. That is, to beyond 1 year, the president can extend by 6 months at a time only when the following two conditions are fulfilled. What are they? The first one is, so if a state imposed by the presidential rule, and then the first condition is the proclamation of national emergency should be in operation in the whole of country or in the whole or any part of the state, then this proclamation of presidential rule can be extended up to 3 years. And another condition is the election commission must clarify or certify that the general election to the legislation assembly of the concerned state cannot be held on account of difficulties. In these two situations, this proclamation of presidential rule can be extended up to 3 years. Let us see how this proclamation of presidential rule can be revoked. This proclamation of presidential rule may be revoked by the president at any time by a subsequent proclamations. So, to revoke this proclamation of presidential rule, it does not require the parliamentary approval. And then we move on to what are the consequences by proclaiming this presidential rule. The president acquires the extraordinary powers when the president rule is imposed in a state. Let us see one by one. What are they? He can take up the functions of the state government and powers vested in the governor or any other executive authority in the state. So president assumes, it takes the power. And then second point, he can declare that the power of the state legislature are to be exercised by the parliament. That is, the parliament can pass the bill in accordance to the state legislature. Number 3, he can take all other necessary steps, including the suspension of the constitutional provisions relating to any body or authority in the state. These are the most important consequences faced while proclaiming the presidential rule. And when the state legislature is thus suspended or dissolved, let us see the few important facts related to this. The parliament can delegate the power to make laws for the state to the president or to any other authority specified by him in this regard. The president can authorize, when the Lok Sabha is not in session, expenditure from the state consolidated fund pending its sanction by the parliament during the state legislature is suspended or dissolved. The parliament, or in case of delegation, the president or any other specified authority can make laws conferring powers and enforcing duties on the center or its officers or authorities. Here, the most important thing is the president can promulgate, when the parliament is not session, ordinance for the governance of the state. This ordinance can survive even after revocation of the state emergency, or else the state government impose or implement the laws to make over such ordinance. So what happens to the concerned state judiciary? That is High Court. The president cannot to himself the power vested in the concerned state High Court or suspended the provisions of the constitution relating to it. The president cannot to himself assumes the power. In other words, the constitutional position, status, powers and functions of the concerned state High Court remain same even during the presidential rule. This is very important point. That is, the judiciary has not affected during the presidential rule. Let us see other few important facts related to the presidential rule. For the first time, this presidential rule was imposed in Punjab in 1951. By now, most of the states have been brought under the presidential rule once or twice or more. Here one has to note that the Chhattisgarh and Telangana has not faced such rule yet. This is very important point related to your UPSC prelims. And then scope of the judicial review. Here 38th Amendment Act of 1975 stated that this proclamation of presidential rule as immune to judicial review. So after which the 44th Amendment Act made this presidential rule is subjected to judicial review. And also in a Supreme Court, in the famous case S.R. Bommai versus Union of India, that is 1994, also suggested the propositions have to be laid down by the Supreme Court on imposition of presidential rule in the state under Article 356. Let us see. This is very important. S.R. Bommai case propositions. Let us see. This presidential rule is subjected to judicial review. It is one of the basic structure of our constitution. And then certification of the president must be based on the relevant material. So this is also very important. And then here the burden lies on the center to prove that imposing a proclamation of state, that is state emergency, that is the burden lies on the center to prove that the relevant materials exist to justify the imposition of that presidential rule. The next is the court cannot go into the correctness of that material or its adequacy, but it can see whether it is relevant to the action or not. And next is, if the court holds that the presidential proclamation to be unconstitutional and invalid, it has the powers to restore the dismissed state government and review the state legislature assembly if it was suspended or dissolved. So next is, the state legislature assembly should be dissolved only after the parliament has approved, that is the presidential proclamation. Until such approval is given, the president can only suspend the assembly, not dissolved. And in case of parliament fails to approve the proclamation, the assembly would get reactivated. Here one has to note that the secularism is one of the basic features of the constitution. Therefore, if the state government runs against secularism or pursuing anti-secularism politics, then it is liable to action under Article 356. So here the question of the state government losing the confidence of the legislative assembly should be decided on the floor of the house. Until that is done, the ministry should not be unseated. Where a new political party assumes a power at the center, it will not have the authority to dismiss ministries formed by other parties in the state. So here one has to know that the power under Article 356 is an exceptional power and should be used only occasionally to meet the requirements of special situations. Here, based on the Sarkaria Commission report about center-state relations and SR Bommai case, Article 356 could be proper only during the hung assembly. What do you mean by hung assembly? Where after general elections to the assembly, no party secures a majority. That is called as hung assembly. Number one, hung assembly. Next is when the party having the majority in the assembly declines to form a ministry and governor cannot find a coalition ministry commanding a majority in the assembly, then you can use this presidential rule, where a ministry resigns after is deficient in the assembly and no party is willing or able to form a ministry commanding a majority in the assembly, then you can implement this presidential rule, where the constitutional direction of the central government is disregarded by the state government, then also you can use this presidential rule during the internal subversion, where for example the government is deliberately acting against the constitution, then also you can use a presidential rule. The next is the physical breakdown, where the government willfully refuses to discharge its constitutional obligations, endangering the security of the state, one can implement a presidential rule. So let us see the improper situations. When a ministry resigns or it is dismissed on losing majority support in the assembly, and the governor recommends imposition of the presidential rule without probing the possibility of forming an alternative ministry. So in this situation, if the presidential rule is implemented, then one can approach a judiciary. And so maladministration, this is also improper way to impose a presidential rule. And then these are the points, so kindly go through the improper situations. And then, does this fundamental rights gets suspended during the proclamation of state emergency? No. The Article 19 and other fundamental rights provided by the Constitution, that is Article 12 to 35, which has not been suspended during the state emergency. So kindly go through this video, and then we will discuss about the possible questions in the later upcoming classes. Thank you. Have a good day.